Since the turn of the millennium, there has been an astonishing amount of uploading and downloading media to the internet. A major concern that often arises from this is if the material infringes upon copyright law. Copyright law protects original works of authorship, including, but not limited to, literary, musical, dramatic, and artistic works. On the internet, copyright issues frequently emerge pertaining to music and videos. One of the largest cases of our generation regarding copyright law is the Viacom versus Google and YouTube case. In March of 2007, Viacom, a New York-based company that owns cable networks such as Comedy Central, MTV, Nickelodeon, as well as the Paramount Movie Studio, filed a $1 billion lawsuit against Google and its video sharing site, YouTube. Viacom accused YouTube of illegally broadcasting over 100,000 copyrighted videos owned by Viacom on YouTube's website between 2005 and 2008. Viacom filed the suit in the United States District Court for the Southern District of New York, pursuing an injunction against further violations and damages. In July of 2008, during the pretrial discovery procedure, Viacom won a court ruling which required YouTube to hand over information specifying the viewing behaviors of every user who had ever watched videos on the website. This request received a lot of pushback and criticism from third parties who were concerned about breach of privacy rights, for fear that users could be identified by their IP addresses. Judge Lewis Stanton disregarded the privacy concerns, stating that users' data was not protected under the Video Privacy Protection Act, because the website was not a videotape service provider. However, Google and Viacom agreed that YouTube could make the user data anonymous, except for employees of both parties, before being handed over. The employee data played a major role in the court case. Viacom quoted internal emails between YouTube executives discussing how to handle the uploading of video clips owned by major media corporations. Google countered by exposing 18 different marketing agencies hired by Viacom to secretly upload Viacom-owned content onto YouTube, which Viacom subsequently demanded YouTube to remove. In June of 2010, Judge Stanton granted Google's motion for summary judgment, which is a request for the court to rule that Viacom had no case due to the lack of supporting evidence. Furthermore, Google was protected by the Digital Millennium Copyright Act, which created a safe harbor for online service providers. This safe harbor protects companies like YouTube by allowing them to not be at fault until infringing copyrighted material is brought to their attention. Section 152C of the Digital Millennium Copyright Act states that, under the knowledge standard, the service provider is eligible for the limitation on liability only if it does not have actual knowledge of the infringement, is not aware of facts or circumstances from which infringing activity is apparent, or upon gaining such knowledge or awareness, responds expeditiously to make the material down or block access to it. Judge Stanton explained that while YouTube knew that copyrighted material had been uploaded to the site, the company did not know specifically what video clips had been uploaded with or without permission from content owners. Additionally, when videos were requested to be taken down, such as Viacom's complaints, YouTube immediately complied and removed the videos. Viacom appealed the ruling, and in 2011, the company brought the case to the United States Court of Appeals for the Second Circuit. Once again, Viacom focused on the specific internal emails between the YouTube executives, which the district court stated could be grounds for YouTube to be disqualified from safe harbor. The judges of the court vacated the majority of Judge Stanton's ruling for summary judgment, with their justification being that a reasonable jury could find that YouTube had actual knowledge or awareness of specific infringing activity on its website. However, the judges did affirm the district court's ruling that three functions of YouTube, playback, transcoding, and video thumbnails, were all protected by the rules of safe harbor. The case was reopened for a jury trial, and in April of 2013, Judge Stanton ruled in favor of YouTube on four issues. A, whether YouTube had knowledge or awareness of any specific infringements. B, whether YouTube willfully blinded itself. C, whether YouTube had the right and ability to control infringing activity. And D, whether any clips were syndicated. Once more, Viacom attempted to appeal the ruling, but an agreement was reached between the two parties a week prior to the appearance in the Second United States Court of Appeals. No money was involved in the settlement. This monumental court case laid out the consensus for many other digital services. In a day and age where media outlets are so impactful in society, companies such as Facebook and Twitter are not accountable for copyright violations if they do not encourage them. Instead, the copyright owners are held responsible for removing unwanted content from these platforms. Furthermore, as defined in Section 106 of the Copyright Act, fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. While fair use did not play a major role in the aforementioned case, Viacom did terminate a YouTuber's account in 2015. Mysterious Mr. Enter was an online critic of television shows owned by Viacom, and the very same company requested for the user to be removed from YouTube due to multiple copyright violations, according to the multinational media conglomerate. YouTube and many other video outlets have had issues with abuse of removing content related to or are critical of the owner's work. Fair use is instated to protect the user's First Amendment rights and to discourage censorship. However, copyright owners often diminish the claims, and action is rarely taken as a response. Another very impactful case of the 21st century was Recording Industry Association of America versus Jamie Thomas. In 2007, 30-year-old Jamie Thomas from Minnesota was sued by the RIAA for illegally sharing songs on the peer-to-peer file sharing application Kazaa. The trial took place at the United States District Court in Duluth, Minnesota. Thomas was accused of sharing a total of 1,702 music tracks online, but the RIAA requested consolation for only 24 of those songs. Thomas denied the claims, and the defense proposed that an unknown hacker could have compromised the computer. The jury was notified of jury instruction number 15, which in summary stated that even without proof of distribution, simply making copyrighted content available for download was within the parameters of copyright infringement. In October of 2007, the court found Jamie Thomas liable for willful infringement. As punishment, Thomas was required to pay a total of $222,000 for the 24 songs that she was accused of illegally distributing. However, the following summer, Judge Michael Davis declared a mistrial. He stated that jury instruction number 15 was erroneous, and that error substantially prejudiced Thomas's rights. Based on the court's error in instructing the jury, it grants Thomas a new trial. In the May 2009 retrial, the defense made the cases that A. Thomas never used Kazaa at all, B. Every song on her computer was ripped from her CD collection, C. Thomas did not download and share any of these songs, D. The supposed accusations did not cause substantial harm to the RIAA and wouldn't even if widespread, and E. Any and all infringements she was accused of were covered by fair use. However, Judge Davis did not accept the fair use argument because it was raised at the last minute instead of the required time prior to the first trial. In June 2009, federal jury ruled in favor of the RIAA with damages set much higher at a cost of $1.92 million. In January of 2010, once again Judge Davis sympathized for the mother of three and reduced her penalty down to $54,000. The RIAA went a step further and offered a settlement of $25,000 from Jamie Thomas, but she refused to pay. As a result of the decline to pay, the RIAA rejected the penalty reduction. The RIAA requested a third trial in late 2010, which resulted in a penalty of $1.5 million. Again, in July of 2011, the court reversed the penalty back to $54,000 on due process grounds. The plaintiffs naturally appealed the decision once more in the United States Court of Appeals for the Eighth Circuit. The Motion Picture Association of America became concerned about the potential impact of the case on the movie industry and filed a brief to support the arguments of the RIAA. In September of 2012, the Court of Appeals determined that the previous trial at the district court was incorrect with their decision. The $222,000 punishment should never have been decreased on the basis of due process, because the number was in fact constitutional. In March of 2013, Thomas declared bankruptcy to avoid having to pay the $222,000 penalty to the RIAA. The 6-year court case was exhausting for all parties. The consequences were so severe and so easily avoidable for Thomas. The price of approximately 3 CDs is less than $54, and her penalty was more than 4,000 times that cost. It's very important for people to know about cases like this because it simply shows that breaking the law is not worth it. With copyright law becoming increasingly more relevant, many proposals for reform have been submitted. Just within the past year, House Judiciary Committee members have submitted a bill titled the Fairness to Small Creators Act. Within the bill are 3 proposals, as listed. A. To give the United States Copyright Office a separate budget to make it more independent of the Library of Congress. B. To establish various committees made up of outside advisors to help the Library of Congress stay up to date on changes in relevant fields. And C. To create a small claim system to handle small infringement cases pertaining to the takedown notices of the Digital Millennium Copyright Act. As expected, opposition was received from technology companies in favor of the free flow of information. Legislative Council member at the Electronic Frontier Foundation, Ernesto Falcon, said that resolving issues in the U.S. Copyright Office is a matter of good management and good oversight. I think they have the ability to do that without a change in the political structure. There will always be a battle between parties concerned about copyright reform, especially in this age of technology. But one thing is for certain in the eyes of the law: stealing is never worth it.